Thank you, Mr Chairman. The fourth part of the bill's most important part, in my opinion, as the Attorney-General's already adverted to, is the way in which people can have rights recognised under this legislation, whether it can be done through Act of Parliament, whether it can be done just with an agreement through the Minister, or whether it needs to be done through the court. I want to come back to that, but can I just, before I do that, I was reflecting overnight on the tone of this debate, which I'm pleased to say is quite measured, and I think it reflects well upon us as a Parliament that it is measured. Thank you, said Mr Quinn. Well, actually, he hasn't taken a call yet on a number of the parts, so maybe that's one of the reasons why Mr Quinn's contribution to this has been measured. But I think it is important to put on record that at the committee stage of the debate in 2004, these are the sorts of comments that were being made, and I'm going to quote some of them. We had Dr Wayne Mapp, current Minister in the government. So what the government is doing here is clearly preferring Maori above all members of the community, so it's very, very clear that we have two classes of citizenship. Maori are in the preferred position. That was Dr Mapp. We had Jerry Brownlee, now Leader of the House, currently the Minister away in charge of earthquake recovery in Christchurch. The bill is designed to placate Maori with a cheque and convince other New Zealanders that everything is okay when it's not. Absolutely disgraceful. We had the Honourable Nick Smith saying that that bill, which didn't go nearly as far as this current bill did, or didn't go as far, Honourable Nick Smith, the bill is racist, the bill is flawed. That was his contribution to the... He said that. I'm reading extracts from Hansard in November 2004. We had contributions from Nick Smith later. Said, well, he said, and he was responding to Dover Samuels, who was responding to fears that had been racked up in New Zealand that the foreshore and seabed bill was going to prevent people having a barbecue on the beach. And those comments had been made by a number of people in the National Party. Don Brash was one of them. Bill English, from my memory, was one of them too. So Dover Samuels was saying that wasn't the effect of the foreshore and seabed bill. And actually history shows that Dover Samuels was right. There's now agreement that that was never going to be the case. And what did Nick Smith said? Dover Samuels said that it would not make any difference to families wanting to go down to the beach and have a barbecue. Well, yes it does, Dr Smith said, and I will tell members why. In relation to the 10% that his Maori caucus claims will now be foreshore and seabed reserves, it will be for the management committee to decide who will be able to have a barbecue and where. Absolutely irresponsible. This was never about the beach. It was about the part of the foreshore that is wet, and access for recreational purposes was never ever at risk and was expressly provided for in the Act. That was one of the most despicable acts of undermining of race relations that I hope will ever see in this Parliament. We then had in the third reading, after all this, Jerry Brownlee again came back, and remember, he was the National Party's spokesperson at the time on Maori affairs. That's why it's important that we remind New Zealand as to how despicable these comments were. He said this is the first time a government in New Zealand has passed a law that is as overtly racist as this one. Now that's the Foreshore and Seabed Act that the National Party now says was not good enough in terms of protecting Maori rights. At the time, they were saying it went far too far. And so when I hear members of the National Party, including Tau Henare, saying apologise to this side of the House in respect of legislation which was not perfect, but it was not nearly as bad as was presented and was done against the climate of those sorts of comments, I say, Mr Henare, look at yourself. Record your own statements on talkback radio. You weren't in Parliament at the time, but you were racking things up on radio at the time. Mr Speaker, Mr Chairman, I want to come to a particular clause or a particular point of difference which I think is one of the largest differences between the National and the Maori Party and the other parties in Parliament now, and that is whether there should be agreements that are able to be made between a minister and the Crown and then effectively given effect to by Parliament. Now, the legislation as it came to Select Committee was even worse than that which has been proposed by the Attorney-General now, and I acknowledge that change. It said that there could be agreements between the Minister and Mr Chairman.
Call the Honourable David Parker.
There could be agreements between the Minister and claimant groups that would be given effect to by way of regulation without either parliamentary oversight or court oversight. The supplementary order paper changes that and says that we can now have legislation to that effect. And the attorney says, well, look, there's precedent for that because that's how the Ngāti Porou settlement is given effect to. Now, the position that other parties in this Parliament have got to is that we think that there should be absolutely fulsome recognition of unextinguished Maori interests in the foreshore and seabed, but we also think there should be no more than fulsome recognition of unextinguished customary interests. If it's more than fulsome recognition of an unextinguished interest, it actually isn't a common law recognition of a common law right, it's actually a treaty settlement. And the mixture of these two concepts needs to be handled very carefully. And so, whilst we support treaty settlements being pursuant to an Act of Parliament, we actually don't support foreshore and seabed or recognition of existing interests in the foreshore and seabed through Parliament, because we think those things are more cost-effectively and more properly, openly, transparently, fairly achieved through the courts. And so that's... Gobbledygook, says the lawyer from the other side. Now look, we already covered yesterday the issue that it's certainly not cheaper through Parliament. It costs about over $2 million for every statute in this Parliament. So the cost of a statute to give effect to a foreshore and seabed agreement is probably worth more than the underlying interest, which is a bit of a nonsense in the first place. And it's certainly costs more than the alternative process through the courts. There are a range of interests. What was that? Not if you take legal aid into account. What I'm saying is that even if you were to subsidise the cost of court processes, it would be a lower cost to the taxpayer than doing it through Parliament. It's patently clear that that's the case. That's what I was saying, Mr Quinn. Now, why court processes are important? There's not a balancing of interests here. There is recognition of extant existing Maori interests in the foreshore and seabed. We all in this Parliament now agree that that should happen. We actually didn't agree back in 2004. The National Party opposed that at the time most vociferously, but everyone in this Parliament agrees that there should be proper recognition of continuing customary interests in the foreshore and seabed that have not been extinguished through history. Court processes, though, make sure that all relevant interests are be taken into account, because if you under-recognise something, you're actually poking a stick in the eye of the Maori claimant, and many Maori claim that that's the effect of this legislation. And conversely, if you go too far and you recognise a customary interest which at common law would have been found to have been extinguished, you're actually abrogating a public right in favour of a private right in respect of that section of Maoridom. Now, the court are the ones that are best placed to make that determination. They are well versed in ensuring that anyone's interests who might be adversely affected are taken into account. They are well versed at protecting property rights of Maoridom, or indeed any other group, against inappropriate confiscation. That's always been their central role. Now, there have been at times courts in New Zealand, and the old 90 Mile Beach decision might be one of them, where they've got it wrong. But now we have the courts saying there are extant interests, they ought to be recognised. Why is it that we think that Parliament should take that over? The High Court has always been the guardian of Maori, or not always, for the last 2 or 3 decades, the High Court has been an effective guardian of Maori aspirations to property rights, whether it be SOE interests, whether it be pursuant to treaty settlements, assets being properly reserved for being available for treaty settlements. It's actually the High Court and the Court of Appeal who have actually guaranteed those rights to Maoridom. It actually hasn't been Parliament that's led that. I'm somewhat ashamed to say that. It hasn't been Parliament that's led that. It's been the courts that's led that. It's been Parliament sometimes given recognition to that and set up processes that have facilitated that, but it actually hasn't been Parliament who has been the primary guardian of those interests. It's been the court. So I, Mr. Chairman, think that this legislation is wrong in saying that we should